SJC-12499, Commonwealth v. Jerome Almonor.
Good morning. May it please the court, Jessica Kenny.
Wait. We appreciate your enthusiasm, but you need to wait until he does that.
I apologize.
So don't lose your enthusiasm, just postpone it. Okay.
Thank you. Good morning. May it please the court, Jessica Kenny for Plymouth County on behalf of the Commonwealth. With me is AD8 Nathaniel Kennedy. I'm asking the court today to reverse the motion judge's order of suppression. In this case, I'm asking you not to take away from the police the ability to locate and arrest a fleeing murderer hours after he savagely shot and killed someone for no reason. I'm asking you to find that the police acted because of exigent circumstances, that they had an objective basis to believe there was an ongoing emergency, and that they acted reasonably when they asked the cell phone company to ping a phone that they knew the defendant had used hours before the murder.
Quicker than getting a warrant?
I apologize?
Asking the telephone company, is that quicker than getting a warrant?
Yes, much quicker than getting a warrant. In fact, in this case, the evidence was that after the police had gone into the home with the consent of the homeowner and located the defendant, they saw the murder weapon in plain view, and they seized the home at that point. They stopped anyone from coming or going, and they did, in fact, write a warrant, despite having at that point a plain view observation of the weapon and consent from the homeowner. But they did seize it, and the exhibit that was entered at the hearing shows that that warrant, by the time it was written, acted on by a magistrate or judge, and then was able to be executed, was 10:15 the next morning. The evidence at the hearing was that it was shortly after midnight when the police arrived at the home, knocked on the door and got the consent of the owner to go inside. So in that case, it took them a little less than 10 hours, about 9 hours, to actually get the warrant once they were able to write out the probable cause and find a magistrate. So I suggest that that would have been obviously much longer time, but that's not a reasonable expectation of the police to have to go and apply for a warrant in this situation, in these circumstances. You had an allegation here, not just an allegation, but the police had very, very strong probable cause that the defendant had murdered someone, not just with a firearm, but with a sawed-off shotgun, a weapon that is per se unlawful and incredibly dangerous. The evidence before the motion judge coming from the witnesses to this was that this was a shooting over nothing. Literally, it was a misunderstanding. The victim was there to see someone in the third floor of the home about getting his car fixed, and the defendant came out and started yelling at him and shot him at close range with that weapon. He was driven away from the scene with the weapon. His friend returned to the scene, the co-defendant, and told police that he had driven the defendant away and that when he had gotten out of the car, he still had that weapon with him. This was broad daylight. It was about 5 o'clock in a residential neighborhood in the city of Brockton, right in the driveway of a 3-family home. There were a number of eyewitnesses to the event inside the home, as well as a surviving victim in the passenger seat. So again, unlike some of the cases where exigency is not found, there is a reason to believe in this case that the defendant could have known not only that his co-defendant had gone back and may have given him up, but that any number of those witnesses there who he knew because his friend was there, the co-defendant was there because his girlfriend was there and his children were there at the time of the shooting. So he knew that people in that building could identify him. They knew who he was. They knew that they left behind a surviving victim. And again, his friend had gone back, the co-defendant had gone back to the scene. So there's much more of a higher exigency here than in some of the cases where it's been found there isn't an exigency.
Could you remind me what Judge Moriarty thought about the exigency question?
He said that there was no evidence that the police could not have obtained a warrant, that they didn't.
You're saying that it was factually incorrect, that on the record presented there was?
That's correct. The exhibit that was marked was the actual search warrant that was obtained, and the second page of it clearly shows that after the police froze the scene and they wrote the warrant, it was 10:15 in the morning before they could execute it.
But that was the only evidence of exigency?
That was not the only evidence of exigency, but I suggest that's the evidence that shows that it would have been unreasonable for the police to have waited to write a warrant. I think.
Did the judge take that into consideration?
I don't know if he did, honestly. I don't know if he noticed that about the warrant. I don't know if he paid attention to that part of the timeline.
Argued?
I don't recall if I did off the top of my head. I don't recall if that specifically was argued. But it was there. It was in evidence. It was marked as an exhibit. And certainly I think, there's that language that talks about having our scholarly after the event with the benefit of leisured retrospect, the ability to say they should have just gotten a warrant. But I think that anybody that's been involved in a complicated homicide investigation knows that it's not just as simple as, oh, go find the judge and you can have a warrant in 15 minutes. And you can tell that from that search warrant that was entered, everything that was happening at that scene as it related to this murder. It was a complicated investigation. There were a large number of witnesses to interview. There were evidence response teams. There was evidence being collected and examined, and police were attempting very quickly to sort of break off and to interview these people and to gather the information to identify suspects.
Are you relying solely on agency?
No. I think that's my best argument, quite frankly, but I'm not.
That's why you put it first, right? You're not putting all your eggs in the agency basket. You're also arguing that it wasn't a search.
I also, correct, I agree. I believe that.
But to echo what Justice Link just asked you, we'd have to find on agency that Judge Moriarty's findings were clearly erroneous.
Correct. And I suggest that you can do that based on the evidence that he doesn't articulate that he considers in his findings, and that is the actual time that it took the police to get a warrant in this case.
Also the fact that the defendant could have been identified in broad daylight, and et cetera.
That's correct.
Now, 2702 provides for exigent circumstances with regard to, but it's limited to an emergency, generally a missing person or whatever else. Are you claiming that this is an appropriate search under 2702?
I am. I believe that the police, I believe this is an exigency where the police could utilize that. An exigency has always been an exception to the warrant
But
requirement.
it's an emergency involving danger of death or serious injury requires disclosure without delay of communications related to the emergency. That's what 2702 permits.
Correct. And so we have a gentleman, a defendant, who has used a sawed-off shotgun to murder a stranger in a driveway in broad daylight in front of a number of people in a residential neighborhood. He's on the lam. He's fled the scene with the gun, and they need to locate him. They need to find him and ensure that there's not future danger, to ensure that that gun, which does, is again dangerous per se and illegal per se, is not discarded somewhere and located somewhere in that residential neighborhood by someone that shouldn't find it. There are a number of inferences that can certainly be drawn and that the police certainly could have reasonably believed were potential outcomes if they did not locate this murderer immediately and put him into custody. And I think nothing better shows that that was their only intent, other than the fact, again, that when they got this ping back, they went to an address that they knew was within the pings, and that's a big point here when we get to the Augustine conversation and we're starting to talk about whether this is a search.
This is before Augustine, because this is a question of whether it's in violation of federal law.
No, and I suggest...
Because I gather 2703 makes no reference to exigency. I mean, there was never a 2703 application here. I mean, very often we get 2703 applications, but not a search warrant. But here, I gather there was never any application under 2703.
No, there was not. There was a request made directly to the third-party carrier under their exigent...
Which is 2702.
Correct.
So does this case rise up? Mr. Spurlock may have a different view, but at least don't you have to get over the first hurdle, which is that as a matter of federal law, it did not violate 2702? I
think that because it was not an emergency, it was just exigent and not an emergency? I'm not sure I understand.
Because it may not, I mean, the argument would be as to whether or not it meets the criteria in 2702, which is an emergency involving danger of death or serious injury that requires disclosure without delay of communications related to the emergency. I think that's the standard in 2702. And since there's not a 2703 application, wouldn't you have to meet that standard?
I would suggest to the court that that standard has been met. Anytime that an individual with a sawed-off shotgun has just murdered someone in broad daylight in a residential neighborhood and is now in that neighborhood, attempting to get away, to evade police, still has that weapon based on the information that the police had, is clearly not afraid to use it, for no reason, and not afraid to use it when people are nearby. That is absolutely, I suggest, that type of exigency that would meet the federal law requirement.
And I gather there is case law with regard to 2702, but I don't think it was briefed, was it?
No, it was not.
Okay, so that's case law that we have not seen, although I've taken a look at some of it, and I guess it's mixed in terms of whether or not a criminal investigative type circumstance would fit into it under certain circumstances.
I can certainly take a look at that as well and provide a letter to the court after.
If you prevail on 2702, is the ballgame over, or do you then have to, or must you do anything else? Is 2702 sufficient alone?
I think under the Massachusetts case law regarding exigency, I think based on the facts in this case that when you look at them as a whole, that the Commonwealth has met its burden to prove that the police acted reasonably given the emergency that was ongoing. And I did file a letter with the court with regard to Raspberry, case of the appeals court that just decided recently, and that case is right on point as well. And I understand that is a promise or a threat of future harm, but again, that case distinguishes exigency from an emergency or the emergency aid exception where probable cause is not necessary. And there is strong probable cause in this case, I suggest. When you review that affidavit and the number of people that had identified the defendant in a very short period of time after the shooting as being the perpetrator, the probable cause was strong. And going back to the point I was making is to show that the police were acting on that exigency and nothing more. As soon as the defendant was in custody, as soon as that safety risk was alleviated, what did they do? They didn't start searching the house. They didn't go knocking down doors. They froze the scene. They wrote the warrant, and they got the warrant before they seized any of the evidence that they viewed in plain view. And I think if that had been available or a possibility, they would have done it before, but they didn't have that time because the public's safety risk, there was a safety risk to the public that needed to be addressed immediately.
You know, the concern, of course, is that it's problematic for law enforcement to use cell phones as real-time tracking devices instead of as communication devices.
And that's sort of the next part of my argument. When you move into the area of Augustine, and Augustine obviously talks about historical, and this is real time, and there's no cases right on point for real time. There's a couple very important points. One, this is a single ping of a phone. The Augustine case law, the Carpenter case, they all talk about tracking someone's movements for an extended period of time and being able to see into their life, see into their religious affiliations and their social circles. And that could not be farther than what happened here.
But it could have been that he was in a home.
It could have been, but there's no evidence that was presented.
Wasn't a home.
He was in a home 50 minutes later when they knocked on the door.
Okay.
At the time that they pinged his phone, the only thing that the police were able to garner from that ping was that it was between a particular set of addresses on Clarence Street. It was their own independent police investigation, witnesses they had interviewed just a few hours earlier who had told them that the defendant had an ex-girlfriend that lived at 19 Clarence Street that made them go to that particular address. And even once there, they didn't just knock down the door and go running inside looking for the defendant.
Is that what Moriarty found, Judge Moriarty found?
He did, yes. He found that it led them to an area within Clarence Street, and that then the interviews led them to ultimately to the.
So it was independently of the ping that they found?
I don't want to go so far as to say it was completely independent, because certainly in the city of Brockton, you know, it's a very densely populated area. It certainly narrowed it down to a city block for the police. That certainly helped, but it did provide them with a range of addresses that, you know. So it narrowed it down. It certainly made it quicker and easier for them, but there is no evidence. The defendant could have been standing in the middle of the street when that ping went off. The phone might not have even been on him when that ping went off. It was a wide range, and they still obtained the consent of the lawful homeowner before they went up those stairs.
And how about, what's the impact of, it's a one-time ping and it's obviously a period of less than 6 hours? What's the implications of that?
I think that's huge. I mean, what Augustine says is you can get 6 hours of historical data, right? So if the police just wanted to look back 4 hours before the murder and see what had happened where he was, right now under Augustine, that would be fine without a warrant. When you think about that, the last ping of a historical order is really the first ping of a proactive order. I mean, that's all the police had. Technically, by the time that was communicated to them by the phone company, it's historical at that point, maybe 60 seconds historical, but it's historical nonetheless. So to say that it's a...
Not real time, it's really just historical?
I'm sorry?
You're saying it's not real time, it's really just historical?
I'm saying that because it's only one ping in this case, because it's one singular intrusion, if you will, it's so minor, and it tells us so little about where the defendant was.
Pings, what does 2 pings do?
Well, obviously, that's a slippery slope. That's why you have Augustine, though, that says you can get up to 6 hours of it. And
All historical?
I'm sorry?
All historical?
Well, the difference, I think, between historical and real time, certainly recognizing Justice Gantz's dissent in that case, the idea that perhaps registration CSLI will be much more frequent and telephone will be much more episodic, that's not always true. I respectfully disagree. Depending on how often you use your phone, you could certainly have an instance where someone who's on the phone all day long is going to have almost simultaneous locations. And additionally, from the research that appears especially in the amicus brief, it appears that this pings off a cell phone even when someone calls you. So for that matter, the police could have taken this phone number, they could have called the defendant's phone, the defendant might not have picked up, but it still would have been pinging off of a tower near wherever that phone was, and then they could have requested from Sprint the historical data with regard to that ping that they had just made 60 seconds earlier, and they would be requesting telephone CSLI in the historical sense, which would all fall under Augustine. So my point is that in this case, I'm not suggesting some big blanket Orwellian picture that is posed by the defendant that the police are just going to track anyone they want, anytime they want, all the time. This is a singular ping in an exigent circumstance that did not provide the level of detailed information that has often been found to violate Article 14 in the Fourth Amendment.
But can I just ask you, I mean, I'm having trouble with the philosophy here, or the theory, I guess. If you're saying that Augustine permits 6 hours of this, 6 hours of pings are what you're after?
Of historical. So Augustine has upheld that, and it's not a bright line rule.
That the police could do this for 6 hours, in other words, in trying to find him.
Of historical. So in Augustine, they were trying to locate, to show
I know,
that-
but you're saying that the real time is actually just sort of a fantasy, that it ultimately is going to be historical.
I just respectfully disagree with the dissent that there should be more scrutiny on the real-time ping because of the fact that it's not always tied to the telephone calls.
Are you looking for 6 hours of it, as a rule?
I think that would be reasonable, given the holding in Augustine.
But don't we have to, then we'd have to reverse that footnote in Easterbrook, wouldn't we?
Which footnote in Easterbrook?
The footnote 12 says that the 6 hours only applies, it doesn't apply to the ping, it only applies to the cell phone towers, right? The 6 hour permission only applies to,
Not to the registration, you mean, the every 7 second kind.
Right, so we would have to back away from that footnote, right?
And again, I think, because someone can simply call a phone and make it ping off a tower, it's fairly easy to create something even more frequent than
I just
7.
want to make sure I understand. Are you saying that footnote needs to be fixed then, because it's wrong?
I'm saying if the court is looking to make a future rule about the use of real-time CSLI, whether it's via a telephone or via registration, that the 6 hour window, and I don't think that there's a significant enough difference in the type of that data for the court to draw a different distinction. I think that it should be equivalent.
But there's a difference. If you're right, you would still have to do a 2703 application if it's investigative, and that would give you 6 hours under the 2703 standard, which is not probable cause.
If it was an exigent circumstance, I think.
No.
sorry.
If it's investigative, 2702 is the emergency
I
circumstance.
apologize, okay. So just a regular D order that we used before Augustine
Right,
came
so
down.
what you would be, again, this is different because there was never a 2703 order, and it seems as you've got the federal threshold.
Right.
And then you have
But that's
whatever we think to do. And one issue, if you say 2702 is triggered, then we'd have to say whether or not a 2702 application, that we will impose a search warrant requirement even for 2702 information. That's a different situation from a pure investigative inquiry for registration information or GPS for up to 6 hours.
There's still a standard, specific articulable facts, the reasonable grounds that it's relevant material to an ongoing investigation. Again, so this idea that the government is just going to track anyone they want, anytime they want, for as long as they want, is not realistic given the parameters that are already there. It still has to be related substantially to an investigation that's ongoing and material to that investigation. And that's going to be reviewable by a judge before it's signed off on, and it's going to be reviewable after the fact as well.
But that's not the facts here, because that would still have required a 2703 application, which you don't have.
Because there was an exigent circumstance, correct. So they didn't, and the point is, exigency justifies not having a warrant, whether you're stopping a car, whether you're searching a purse, whether you're looking at a house. If you have exigency, you have exigency. And just the fact that it's data on a phone, I don't think it should be treated any differently. It's still an exception to a warrant requirement.
That's a separate issue as to whether 2703 has an exigency exception, even though it doesn't say it does. But you're arguing 2702 here, which is a sort of an emergency aid exception.
Correct.
I'm just trying to understand. So for you to win, all you need is exigency justifies one ping. Is that basically what you're saying?
It can be that simple. You don't even have to wade into the Augustine waters. I mean.
Now, if the one ping identifies the cell phone as being in a house, what do you do with Kylo and Caro?
Well, again, I think that there's a distinction there, because in the case with the infrared, that's Kylo. Again, they talked about viewing the interior of a home with technology that is not generally available to the public. That's like sort of the catchphrase there. So you're pinging a phone. All it's telling you is that a phone is in there. And assuming that it's someday gets to the point where it is so pinpoint and specific that we know that it's in a house and not just maybe in a front lawn or in the street in front of it. Assuming that, I still don't think that knowing that a phone is in a house is necessarily the same thing. And I think
Still have Caro, which said knowing that a beeper is in a home is a Fourth Amendment search. Caro is the problem for you more than Kylo, because that was simply a beeper being present within a house, and they said that arguably would.
that's still, and if I remember correctly, the police put the beeper there. Is that correct? I mean, this is different. This is a cell phone that someone has themselves, and I think that sort of goes back to the Kylo distinction I was going to make.
Can I ask, is Caro an exigency case or not? I just don't remember.
No, I don't believe it was.
Search
no.
case. It's
It
a
was a
beeper.
search
It's
case.
a
So
beeper
that
put
you're just saying in exigency, you get a ping. We don't need to worry about Caro or the marijuana,
No, because
infrareds.
And the exigency is an exception to the warrant requirement.
always. You can walk into a house, you can stop a car. If you have proper exigency, it's always going to be an exception.
Now, is there a concern that the exigency you're describing would devour the rule because it would permit, for serious investigative crimes, would always permit this type of inquiry?
No, I mean, and this court has decided that before. There's no blanket rule about the use of firearms, but this is a little different. This is a sawed-off shotgun. It's different than just a firearm, and this one is actually used. I'm drawing distinctions between the specific facts in this case and other cases where it's been upheld in Massachusetts that there was not an exigent circumstance. And I think every time you look at those cases, there's something a little bit different about this one.
And here we have someone who does it during the daytime, could be identified, and he, as you said, is on the lam.
Exactly.
Okay, thank you.
Thank you.
Mr. Spurlock, still good morning.
Good morning, Mr. Chief Justice, and may it please the court. Matt Spurlock for Jerome Almonor. With me is Randall Power, trial counsel for Mr. Almonor below. The power to commandeer any cell phone into a remote tracking device is unprecedented and uniquely intrusive. Pinging a person's location without a warrant violates bedrock expectations of privacy and exposes fundamentally private places like the home to police examination. Now, police
But you're not examining the home. The way this was just narrowed is, in an exigency, in a crime of this level of violence, they can ping to find him. That's not probing, what he's doing in the home or, address that before you get into the larger dangers of this.
Sure, they're learning the most important thing about the home.
A little louder, sorry.
Sure, they're learning the most important thing about the home. That is the target's location in the home. And that was enough in Caro, the location of the canister.
Carroll was
in the
not
home.
an exigency case, right?
Sure, yeah, but what they're learning is the most important thing about the home, which is what Article 14 protects against, is when the police invade a home, even if it's technologically facilitated, and to learn something about the home inside, even if by inference, like as in Kylo, inference about the marijuana grow operation, that is enough to implicate constitutional concerns and to require a warrant.
But didn't they have some instrumentality that allowed them to know that it was hotter in a different area of the home than other areas?
Sure, that was the purpose of that
Right,
search. They were
yeah.
looking for heat coming from inside the home.
Exactly.
And here they were looking for the location of the target of the search. And they did that by commandeering his cell phone. They did that by causing his cell phone, which it wouldn't have done otherwise, to ping back, to communicate with the satellites, and the satellites then communicated with the carrier. That is, quite different than the situation that we have in Augustine or Carpenter, where we're looking at business records of telephone calls. This is a police-initiated ping. The police are taking control of his cell phone, similar to what happened in Connolly.
Well, suppose they did what the Commonwealth suggested, which was to call the cell phone.
That would be a different case. I mean, I think the distinction that this court drew between registration, CSLI, and telephone, CSLI, is crucial here. I think if the police, want to circumvent that rule by calling a cell phone, of course the target cannot answer the cell phone. Presumably, if he answered it, then that might fall under the Augustine and Easterbrook rule. If he doesn't answer it, it doesn't. And what we're talking about is registration CSLI, or here something much more intrusive than registration CSLI.
Why is it so different from one? If you turn on the phone, it will ping. The other one, if you make a phone call, will ping. Why is that so meaningfully different?
I think the distinction that this court drew in Easterbrook is a distinction between an active act of making or receiving a telephone call. And according to the dissent in Augustine, which was incorporated into the Easterbrook rule, you do have some lessened expectation of privacy in business records that disclose where you are when you choose to make or receive telephone calls. Now, that's entirely different from whether you reasonably expect the police to choose to turn your phone into a remote surveillance device. Those are two different questions. And I think that's why the line between telephone call CSLI, which was the question in Augustine, Easterbrook, and Carpenter, and registration CSLI, and even further from that is what we have here. We have something that the police initiated. This is no different than the police, causing your phone, your smartphone, to take a photo of where you are, or to surreptitiously turn on.
It's different. I mean, because if they're taking a photo, I may not be dressed, or I may be doing something I'm not supposed to be doing. But if they're just pinging, all they're finding out is where I am.
Sure, I grant that. This is still very intrusive, though, to the extent that we do have an expectation of privacy in our locations in private. And that's also why it's different from the GPS vehicle tracking cases that have some sort of durational requirement. We've never had a durational requirement for when the police learn something about the interior of a private place. And cell phones will usually be with their owners in the interior of a private place.
Usually, I don't know about that, they could be on the street. Suppose he was in front of the house, not in the house.
That's true, they could be on the streets. The way that this court conducts constitutional analysis does not lend itself to post hoc analysis like that. So we know that most of the times cell phones are with their owners, and most of the times in every 24-hour period, day and night, their owners are not in public view. We also know that this GPS ping here was quite precise. It's on page 60.
A block, right?
I don't agree with that, Your Honor. I think that in 2012, the GPS information they requested from the police was for precise latitude and longitude, and that's what they received. It's on Record Appendix 64. It's GPS latitude and longitude decimal degree format, as I show on pages 64 and 65 of the red brief. In 2017, it leads directly to the house. Now, there may have been some ambiguity in 2012 about the range of addresses that it could correspond to.
What did Judge Moriarty find?
He found that the police were only at the house because of the GPS.
No, you're not answering my question. What did Judge Moriarty find regarding the precision
He found that it led them to somewhere on that block.
Okay.
And then further in his order, he found that they were only at the house because of the GPS. To the extent that the
But so, to answer my question, you agree with your sister that he found that they were led to a range of addresses when they plugged in through Google Maps,
yes.
right? Then they have the information. What you are alluding to is the attenuation argument.
Yes, that's correct.
But
I
that's
w-
the but-for on that.
Yes, but I would point out that the way that the court conducts constitutional analysis is not what the technology was in 2012, but it definitely takes into account the advance of technology and the progress of technology. And so even a few years later, Google Maps leads you directly to the house. And in 2012, I will point out that the map that the police received on that day, the heading for the map showed the range, but on that map, it is pinpointed and the place where the house is on the street.
Do you agree that if a teenager is kidnapped in a van off the street and the police have an identification of one of the perpetrators, not probable cause, but they have an identification and they're trying to locate that van, that they could ping the cell phone in that circumstance?
They have one of the perpetrators'
They have
cell phones.
Yeah.
Sure, in a hostage type situation, that would fall into one of the carefully and narrowly drawn exceptions to warrant requirement.
Okay, so we're dealing, okay, so.
That was
so
not this case.
I appreciate that. I'm just trying to make the point. There's gradations. There's at some point in time, some facts don't reach that level, other facts easily reach that level, and we're trying to find where we are.
Yes, and here we are, just to be clear, we're 7 hours after the incident. The police had the ability to ping him for 3 hours before the search at issue. So, taking the impracticability standard as Justice Seifer defined it for us earlier, it is certainly not impossible for him to get a warrant. In fact, it would have been easy for him to get a warrant. And I'd like to address what my colleague...
Significance, I'm sorry, I don't understand the significance about the delay.
Well, I think the delay goes to show that there were no exigent circumstances. If it really was an exigency, the police would have immediately pinged him.
And as soon as they got the information.
Instead, they waited 3 hours. So that goes to the 3-hour gap between learning about the phone number and actually calling to get the ping. Of course, there's a 7-hour gap, and it's their burden to show some danger to police or others. Not a hostage situation, as Justice Lowy hypothesized. There's no reports of other shootings in the area. It's certainly not...
That this guy likely was the owner of the gun and had killed somebody. Don't you think that's pretty telling?
Certainly, and I think that there would have been probable cause to get a warrant if the police had pursued that avenue. And I would just like to point out that getting a warrant is not complicated in these types of scenarios. My colleague is for the first time in this appeal asserting that the fact that the police got a warrant, a 15-page warrant, the next morning proves that it would have been difficult to get a warrant. But in fact, under the Connolly and Augustine standards, all you need for a GPS ping warrant is probable cause that an incident occurred and that the GPS ping would lead to the person who had probable cause to believe committed the offense.
So wait, so you said all you need is probable cause the incident occurred, but that's
Probable
not
cause that the
true.
incident occurred and probable cause that the GPS ping would lead to the person who...
That's a bit of information that you need to know.
It's not a 20-page...
You need to know who the person is.
Here they had a phone number. You don't need to know who the person was. You need to know that the ping would lead to that person.
Would you get an application for a warrant for a phone number?
That's what
they
you
did.
do, yes,
Okay.
under the Connolly or Augustine standard.
Can I go back? You had your new technology argument about 2017 versus 2012, that we need to take into account the new technology, right?
Just to be clear, I don't think my argument rests on that, but certainly I think it was,
But
I think the search occurred.
I want to apply that to the point about calling the phone now. So the technology has now changed. We now understand you can call the phone. So it sounds like the difference between using the phone and calling the phone is being shrunk by new technology. So does that cut against you on that argument while it cuts in favor of you on the other one?
Justice Kafker, I'm not sure I understand the question, but if I understand it correctly,
You said we should project into the future. We should take into account technological developments in terms of interpreting this data, even though in that case, 2012 data is different from today as we sit here. But if I do that with the ping, you start losing, because they've now found a different way to ping the phone. So,
I don't agree with either of those premises. I think
yeah, I thought the first was your premise, but if I misquoted it, ignore it,
I think the data that they got in 2012 is the same data today. It's precise GPS data. How the police can translate that data through Google Maps in 2012 versus Google Maps in 2017 is another question. But the search occurred when they received that data from Sprint, and that data is incredibly precise. It leads directly to the house. And this court and the Supreme Court have always taken into account the progress of technology. We don't need to hypothesize where technology will go. We know where it is today.
Is it the luck of the draw that a person is at a home as opposed to on the street?
No, that's only one of the reasons for affording protection. As I said, I think a person will usually be not just on the home, but away from public view.
How about at work?
Excuse me?
Persons usually spend some time at work, commuting. Half their lives are not at home.
Yeah, a good part of their lives. Some of that, they're not always, of course, in public view at work either. But
let's assume that the other 12 hours are in public view. What does that mean?
I don't think it means anything in terms of constitutional analysis, because my argument.
If you ping and you locate somebody in a public place, then that's okay.
I don't think so, because the pinging here, just to re-emphasize, was a commandeering of the cell phone that was a possession and an effect of the target. It's not a business record where in Easterbook there is somewhat a reduced expectation of privacy in a business record only with respect to telephone calls, not with respect to registration. But this was something where the police reached in and caused his phone to do something it would not otherwise have done. It's no different than the GPS.
Really? They reached in and it wouldn't have otherwise pinged?
Exactly. It would not have otherwise pinged. This was not even registration CSLI.
How did they do that?
Very simply, it's required by the E911, the Federal Communications Regulations, that every phone have the ability to communicate at will with the carrier. And so the carriers, when they received this request from the police, they activated that process.
Well, they're not going to wait for the next ping, in other words.
Exactly. That's what happened here.
So you're saying that the commandeering the phone is like in Jones putting the GPS on the vehicle?
Certainly.
Property-based.
That would be an alternate basis to affirm, and it of course, there are two sides of the same coin. You also have a reasonable expectation of privacy that the police will not do that at any point, that they won't reach into your phone and cause it to take a picture, turn on the recording function, or communicate back.
Nonetheless, you're saying that the property-based argument is a minimum.
It's a minimum, absolutely. And then we also have, of course, the CATS test, which this also meets. But here, both these tests converge on the necessary conclusion that this was a violation of his Article 14 rights.
So what is your view as to whether 2702 applies here?
I haven't explored that question, and I sort of think it's an opposite to the constitutional question. In my research on that statute, it's usually applied to immunize the telecommunication companies from civil suit for handing over this information way shouldn't have otherwise. The constitutional question is distinct. I would also like to point out that—
Is it your view that where there is an emergency, there is a missing person, that you would need a warrant in order to get that information as to where that person is located?
No, I think under Article 14, the exceptions to the warrant requirement absolutely apply. If there is, truly an exigent situation, as there was not here, as Judge Moriarty correctly found that the Commonwealth had not met their burden on any of the prongs of the exigency exception, of course that exception would apply.
But if you lose then, if we decide his findings are clearly erroneous, this becomes a small case, right? It's not a big deal because you're saying if there is an exigency, they do get a ping. In Justice Lowey's hypothetical, the child is kidnapped in the car, we know who it is, you get a ping, right? So if sawed-off shotgun murderer, if we find that's an exigency, is that any different?
We have no argument with the exigency exception applying with respect to pings, but not in
That's
this
what I
case.
mean, is that this becomes sort of if we find the facts are clearly erroneous, there's not a lot of constitutional analysis here. The ping is okay.
Well, I think that would be a constitutional analysis, whether the
It's not
exigency applies.
it's not difficult or not.
I agree with that, but I'd like to point out that this was 7 hours after the incident. This was a cold case.
I totally understand
Okay.
that issue. It just becomes a fact-finding issue. Right.
Yeah, to the extent that the court does not rely on the Commonwealth's theory about the cell phone in and of itself creating an exigency, that truly would be a novel form of exigency, and that's my understanding of what they argued below. And I haven't seen them argue that here today, but the idea that you could turn off your cell phone and that ability in and of itself creates an exigency, some sort of imminent exigency in the act of owning a cell phone. I think that would be quite radical.
Can I ask you a question? If somebody turned off their cell phone, could the phone company still make it ping?
Not as far as I understand the technology. I think you can turn off your cell phone. You cannot, because of the E911 regulations, you cannot turn off the ability of the phone company to reach into your phone and cause it to ping back.
So why on TV do all the criminals take out their SIM card?
I can't answer that, I'm sorry.
Okay, now I'm really confused now. So you're saying the phone company can, even if the SIM
Not
card
if it's
is-
turned off, but it's impossible to disable if your phone is on. You can
if
turn
your
it on.
phone remains on, but I'm saying if your phone is shut off,
If your phone's shut off, then it's true, they cannot
they cannot ping it.
ping you. Yes.
Okay.
Okay. I will invite both parties to address the issue of whether 2702 would apply to this case, since it was not briefed. So I invite 16L letters from both
Okay.
as to whether or not this would fall within the emergency exception of 2702, and if it does or if it does not, what the consequence is of that.
Okay, thank you, Your Honor.
2702 speaks about the provider in good faith believes that an emergency involving danger of death or serious injury requires disclosure without delay of communications related to the emergency. And I believe there is case law that addresses when its information is obtained pursuant to 2702, whether or not it indeed was obtained and whether or not it should be suppressed for failure to meet that requirement. Because here there was no 2703 application.
Sure, and just to be clear, our position is that this information does not fall under the Stored Communications Act at all. The Stored Communications Act refers to records and stored historical records. When the police are reaching in and causing your phone to essentially create a new record, that it does not fall within that statute. And I've provided a 16L letter citing a Fifth Circuit decision that collects some authorities explaining that.
So you're saying that there's never a requirement to file 2703 or the 2702 when you're seeking this information? This falls outside any federal statute?
No, it doesn't. Under federal law, you would need a warrant under Federal Rule of Criminal Procedure 41, along with the tracking statute. And under Massachusetts law, you would need a common law warrant under Connolly and Augustine. So there is a statutory way to get this information. It's not through the Stored Communications Act and those low subpoena-like standards. It's through, under federal law, a warrant, or under state law, a warrant.
Okay, so I missed that. So you're basically saying that 2703 refers only to historical information and does not refer to the real time?
Yes, absolutely.
And that there is no federal statute which addresses the issue of whether or not, when you can get real time, whether it be one ping or multiple pings?
There is a federal statute. It's a warrant under Federal Rule of Criminal Procedure 41 combined with the tracking statute, which I believe is Section 1331. And so you combine both those things, and under federal law, you can attach a tracking device to a car, or you can cause someone's phone to ping back. But that requires a warrant under probable cause.
So,
And-
go ahead.
I'm confused then. So are you saying there's no exigency exception for one ping under federal law?
No, there is an exigency
Okay,
exception.
so there is
absolutely. The baseline is probable cause, and just like all warrants,
No,
can
but you
have-
don't need so you saying under state law, if there are exigent circumstances, you don't need a warrant for one ping. But are you saying under federal constitutional law, in the hostage, Justice Lowy's hypothetical, the child is being kidnapped in the car, they know who it is, and you can't get a ping under it's a violation of federal constitutional law to ping?
No, you can ping if the exigency exception applies, you can ping.
Right.
But the baseline is a warrant based on probable cause.
But I get it, that's the baseline, but if there's exigent circumstances, we're outside of that.
Absolutely, under federal or state law.
And is the exigency different than it would be as described in 2702? Is it broader?
I think the common law of exigency is a bit broader than that. In this state, the court has described it as also including, loss of evidence and risk of flight, whereas the 2702 statute describes it much more narrowly. I think the common law.
So we're in the strange position that if they had said, if they had gone to the provider and said, give me information with regard to historical information over the last hour, they would be in 2702 or 2703 world. But where they say, can you ping him, you're outside, you're in a beeper world, you're in a GPS world.
Absolutely, and that recognizes how much more intrusive real-time tracking is.
Well, but there's a difference, isn't there, between real-time tracking versus causing somebody to be pinged? You could real-time track without generating the ping.
If I understand your question, it's a hypothetical about whether the police could request information about every time the phone registers,
Yes.
perhaps something like that.
Yes.
And that would fall in the middle ground. That's not this case. We're on the far side of that continuum where the police are commandeering the cell phone. That falls in the middle where the cell phone user does nothing active and
The police do nothing
the
active.
police do nothing active. That is real-time registration, CSLI. And Easterbrook teaches that for that sort of information, it does not fall under the Easterbrook 6-hour exception, which applies only to telephone call, CSLI, for all the reasons described in the Augustine dissent.
Under your analysis, where the police generate the ping, we would never be in the position that the Commonwealth argues that this real-time has now become historical, because that ping would not have existed.
Exactly.
Okay.
If there are no further questions, I ask that you affirm the motion judge's order.
All right.
Thank you.
Thank you both.
Further questions?